Hello, my name is Joel Z. Williams. I'm the Director of Products for Peaceful Operations. People in my neighborhood know me as the Poor People's Advocate. Today I want to talk about two issues. The first one being the implied warranty of habitability. The second one, I want to make a call to action for people who live in Philadelphia that are suffering from bed bugs. Now, first, what I want you to know about the implied warranty of habitability is the notion that this is the first time this case, the decision that happened in May of 1970, was the first time that the courts here in the United States said that a tenant could withhold rent if the landlord was failing to give them a domicile that was fit for human habitation. So that's this long-term implied warranty of habitability. A lot of people get confused by that. What does it mean? It basically says that you have entered into a contract with the landlord to provide you habitable dwelling in exchange for rent. Now, going back, let's take a look backward at this case. Now, this case was actually the litigation began in 1965 at a place called Clifton Terrace Apartments in Washington, D.C. Now, this is a 285 unit structure. I think it's 3 buildings. It used to be, when it was initially built in 1916, it was a very swanky luxury type of apartment complex. As time went on, of course, the property value declined. The place fell into disrepair, and by the late 1960s, it was predominantly inhabited by African Americans in D.C. It was owned by a white man, a lawyer, a very successful businessman named Sidney Brown, who he owned a lot of properties throughout D.C., but he became a slumlord, and he was very negligent in keeping up with the maintenance in the building. Well, Ethel Javis and 4 of her neighbors decided that they were not going to pay rent, that they were going to withhold rent, and the company that Sidney Brown owned, the First National Realty Corporation, sued to evict them under the grounds that they had breached their contract, that they had agreed to pay rent, and it's because they hadn't paid rent, they should be ejected. Okay, so what's important to know about this case is Ethel Javis and her neighbors, her co-defendants in this case, had called the housing inspectors from D.C. They had an inspector that had at least 1,000 violations that he was willing to come to court and testify about. They had collected mouse droppings, dead rat droppings. I think they even had cockroaches, and they had all this evidence that they were ready to present, and the judge at the lower court said no. That's inadmissible. So they lost their case at the lower level, and let me make a brief statement about that. If you live in a small municipality in America, it's important for you to remember that many judges are elected for those positions, and they have to face re-election in order to stay in office. Now, a lot of property owners, especially multiple property owners, will donate to judges' election campaigns, and so because they know that there's a likelihood that sooner or later one of their properties, they're going to have to defend in court. Now, there's an old crooked lawyer saying that says that it's a wise attorney that knows the law, but it's a great attorney who knows the judge. And that is a maxim that basically says that there's a lot of cronyism, there's a lot of one hand washing the other at these lower court venues. I think that was the case in this situation. All the defendants were African American, the owner of the building was white, the judge was white, and this case went to appeal because they were not able to admit the very crucial evidence into their hearing. On the D.C. appeal court, on the review, judge named Skelly Wright was his name. He ruled that that evidence should have been admitted. That here is a D.C. housing inspector who has 1,000 violations at least that he's willing to testify in this apartment complex. That should be admitted. And when they did that, they won the case. Now this case, it's called Javis versus First National Realty Corporation, is the first time in the 20th century here in America where it codifies, where it puts into legal language that a tenant can withhold rent, is not obligated to pay rent if the building or the dwelling that they are renting is not in compliance with local housing laws. Now, disclaimer, I don't want you to go out and not pay your rent because you saw this YouTube video and you think that that excludes you. What I'm making this video for is that you will pick up the phone, hopefully, that you will see something that renders your apartment uninhabitable, pick up the phone, call a landlord, tenant lawyer, and ask to speak to them. Most of them will give you a free consultation for 30 minutes for free, or even talk to you on the phone. Okay, so you're not going to spend a lot of money just asking a few questions. Now, let's talk about what renders an apartment uninhabitable. Typically, these are things that that nobody would rent the apartment otherwise. Let me use the Apple analogy. I like to use this analogy because I think it's very simple. Let's say that I am a vendor who sells apples. You want to buy apples from me. You are going to take those apples and maybe make them into pies, or maybe crush them down and make apple cider, or maybe even just sell them as apples, whatever. You contract with me and I'm going to sell you a bushel of apples for $15. We sign the contract, and on the day of delivery I show up and I give you a bushel of apples. But these apples aren't good apples. These apples have worms, they're bruised, they're dented, they're of no value to you because you can't use them, right? So under contract law, I have breached that contract because I have given you something that has it's not merchandisable. It has no value to you, right? So you should not be on the hook to pay me for those apples because you can't use them. Same thing applies to under the implied warranty of habitability law. If you have an apartment where the water is not working, where there's a huge hole in the roof, where the toilet is inoperable, the doors won't lock, there's no fire protection, there's no smoke detectors, the windows won't open or close, there's no ventilation, there's no heat in the winter, these are conditions that would render an apartment valueless. If the landlord was to open an ad in Craigslist or in a classified newspaper and say, for rent, 1-bedroom apartment, no running water, big hole in the roof, rats the size of cats, cockroaches, the toilet won't flush, nobody is going to rent that apartment. That apartment has no commercial value. So under the implied warranty of habitability law, a landlord has breached that contract when your apartment no longer is fit for human habitation. Okay, so that's in a nutshell. And I want you to know that almost every state in the union, I think only Louisiana, maybe Mississippi, has some law that says that if the place isn't up to housing code, then you can be you're not obligated to pay rent. Now, I want to tell you that to say that you shouldn't just automatically stop paying rent. Usually most of these states have some kind of hurdle that you have to first overcome before you can make a claim to stop paying rent. Usually that's tied to notice. The judges want to see that you put in writing exactly what the flaw or the defect or whatever the problem was with the apartment. You wrote it down and you gave it to the landlord as proper notice. Usually require 72 hours notice before you hire a third party to come in and fix it and withhold that money from your rent or otherwise. But they want to see that you have put the landlord on notice that there is in fact a violation of housing code. And usually you can do this very simply by calling the housing inspection. If you know that there's rats in your building, if you know that the landlord has no fire protection, if you know that the front door is not locking, you know that there's no heat working in the wintertime, call the housing inspectors. Have them come out and document that. And that is proof that any court will admit as evidence. Okay, now that I've gotten through that, I want to go to a call for action. The second purpose of this video was I'm getting a lot of complaints from people in the local area that don't know how to build my CO2 bed bug trap. They don't know how to do mattress encasement, or they don't know how to apply the Cemexa powder I advise as part of my Williams method. So what I'm going to do, I have limited resources and limited time, so I can't do it for everyone. But for extreme cases, for single moms that have children, and you live in the Philadelphia area, and I mean inside the two rivers, in between the Schuylkill River and the Delaware River, I will, if you call me and make arrangements, I'll come out. And I have the materials, the plastic, the Cemexa. I will come out and help you with one caveat, with one exception. I need to be able to film it. I need to be able to document it. I need you to sign a photo waiver allowing me to use the footage of that tape in the YouTube video, because what I want to do is I want to give people real world examples of that this works. I'm getting too many people too many naysayers who are like, I'm not sure this is going to work, I'm not sure. I've been into over 300 dwellings and helped people, but nobody wants to let me film it. Everybody's, I don't want to be on YouTube, I'm scared, I'm nervous, I don't want people to know I have bed bugs. If you will allow me to film, and we'll keep your face out of it, but if you allow me to film, I'll come out there and help you for free. Alright, so that's the two things I want you to take away from this video, is the implied warranty of habitability. You do not have to suffer quietly if you are in a place that is unfit for human habitation. There is something you can do. Now, I don't want you to act unilaterally. I want you to call your local attorney, call a landlord-tenant attorney, or attorney that specializes in that field of practice, and get the ball rolling. But you don't have to suffer quietly, and you don't have to pay rent for substandard housing. The second part, call to action. If you know somebody living inside Philadelphia that's suffering, especially single moms with a lot of kids, hit me up and we'll see what we can do. Again, my name is Joel Z. Williams. I am the Poor People's Advocate. You will recognize me by my white hat, but you'll know me by my good works. Thank you.